अपना माइक म्यूट करके रखें। आप गाना सुन रहे हैं, मूवी देख रहे हैं, क्या कर रहे हैं, उससे मुझे कोई कंसर्न अभी नहीं है, क्योंकि अभी आप घर पे बैठे हुए हैं। तो in the last class we have discussed about the international organization as a subject of international law, and in that particular point we have discussed that how with the passage of time new entity has come into got international legal personality, and after getting that international legal personality they become part of or subjects of international law. So in that particular process we are still waiting for that time where individuals can be directly, we can call that individual be subject of international law. So whether that any possibility is there, whether international law is working on that particular topic, that in a time will come where we will say that individuals are also subjects of international law. So we will look into that, because when you look into the definition of Oppenheim, which I have discussed in the last class also and in many classes, because it is important definition as compared to if you study international law, you have to have idea about what Oppenheim has said in the first definition. So he always talked about states in international law, but after state some new thing come into picture and some new entity come into picture, and that also get international legal personality, and on that basis we say that this is also subject of international. So on that basis, before at that even you have you can see the changes in the definition of Oppenheim while his new yes, Prabhu.
Sir, few students are saying that they are waiting in lobby.
Nobody is waiting, Prabhu. I am seeing that only. My screen is there only. I'm looking into that.
Okay.
Ask them, or you can share the link. Otherwise, I think the most of people.
The link is on the group only. I shared it.
Okay. Okay. So nobody is waiting. I'm looking into that. So in this particular topic we are discussing about that now a time have right now we can say a time has already started where we have to recognize individuals as a subject of international law. The question is the most important thing, that international law is basically what it's doing is it saying that it is for international peace and security, the basic one of the aim or objective of the UN Charter or any international organization. So after studying so many international organizations, there are so many international organizations, and after that, what can be the future of international law? Whether in future we can say that the individuals can also a subject of. Now, what is benefit to be a subject? What will be the benefit to individual if they become subjects of international law? What will be the benefit? The benefit will be that when you become subjects, you get international legal personality also. You have rights and duties. If any state or any international organization breach that right, you can bring claim to that also. So this is the possibility if an individual become and subjects of international law. But when you look into the classical international law, that means that in the past, individuals are not considered as the subjects of international law, but they are regarded as an object of international law. So this was the one you can say the past of the individuals in the international law. The Charter of the United Nations in the preamble has given a place of importance to the individual also, and they are trying to change the position. They are trying with different legal documents, international documents, they are trying to start or they are trying to recognize the individual as a subject of international law. They have given so many there. I will discuss these important articles of different international treaties where they have tried to convey that individuals have some rights, individuals have some duties, and if there is a breach of right, they can claim compensation. So these all things are there, but in reality, we have to look into the thing that in reality, individuals are less, we can say, equipped with less powers were given, less rules were there for the favor of the individuals. So this, if you in a gist, I want to convey that if you look into that, that individuals have given some type of consideration in international law, but in reality, that is only a paper tiger. That means because that
we are the positions of international law, a position of an individual in the international organization.
International law. Yes, yes. In not international organization, in international law itself. because we are basically looking into the subjects we have already covered. That when I'm saying subjects of international law, that means on which the international law works. So the first thing we have discussed the states, because without the states we can't have an international law. Then we have discussed international organization, where there is a combination of the states, and on a particular treaty we have an international organization. So these are subjects of international law, but we have to look into whether individuals are subjects of international law or not. So when you look into this concept, you will find that individuals are not directly subjects of international law. There are few treaties or conventions which provide this opportunity to the individuals and subjects, but it is not directly given. That particular, we will discuss that criteria, that why this particular thing is not available to individuals. Somebody's mic is on. किसी का mic on है, off कर लीजिए. Saksham Verma. So this is basically we will discuss about that the parent position of individual in international law, because that is more important in, yeah, we can say in a way. So there in international law the subjects, we will discuss the subjects, and why subjects is important, because in subjects we generally say about that rights and duties are there. So when we discuss these rights and duties, so we say that if there is a breach of rights, they can claim compensation. But in what will be the position of individual, what is the position of individual right now in international law? So the first right which is given to the individual is right of some rights of individual is human rights. One of the principles of United Nations is to promote, encourage respect for human rights and fundamental freedom for all. The UDHR, Universal Declaration of Human Rights, was adopted by General Assembly in 1948, which provided various rights to the individual. That means the one of the aim was international peace and security, and also the UN Charter also say that one of the objective of UN is to provide human rights to all, to respect for human rights and fundamental freedom for all. This is one of the important objective of UN, and for fulfilling that objective, UN has created UDHR, Universal Declaration of Human Rights, in on 10th of December. They have adopted this on 1948. We generally on 10th of December we celebrate Human Rights Day. So due to that reason, because on that day UDHR was enforced. So on that basis, we can say that UN is trying to put that on the basis of human rights, we can have some way, we can provide some benefit to the individuals. Now, what is human rights? Human rights are inalienable rights. You can't take that right from anyone, whether that person is citizen of a country, whether that person is a stateless person, whether that person is a refugee, XYZ, any person can be basically have the human rights, because as a he has born as a human, he has the human rights. So that is also important. So, but whatever the UDHR is providing, UDHR is not providing legal enforcement of that particular, whatever UDHR has given in their articles, they are not giving legal enforcement, or has UN has not provided legal enforcement mechanism for achieving those targets. So that means if UDHR is saying that they will provide each and every human right to the individual, but the same UN is not able to provide the legal enforcement mechanism for those, just like the fundamental duty, that directive principle of state policy. We have the good directive principles are there, but we are unable to enforce that. In the same way, UDHR, very good important human rights things were written in the UDHR, but UN has not given the power to enforce or bring that particular rights come into effect. So one of the loophole of that particular UN UDHR is that we are unable to enforce that. So another thing, the International Covenant on Civil and Political Rights, an international protocol to the Covenant on Economic, Social, and Cultural Rights, along with an optional protocol to the Covenant of Civil and Political Rights, were adopted in 1966, and wherein the contracting parties declared that they would provide different rights to as to the stipulated covenant to the individual. That means when you look into the ICCPR, when you look into the ICESCR, you will find that these additional or even the additional protocols say that they will provide individual rights. But when we look into more deeply into this covenants or the additional protocols, you will find that these all documents are basically paper tiger. The reason I will discuss in few minutes, that the reason is very much different. We can say that very much different. that why there is this type of differences are there. Even we have provided the rights to the individual. The reason is that we are not represented as an individual on international law. We are represented as a part of a state. So without the help of a state, you can't be part of any we can say any international forum. You can't bring that particular matter to the international forum without the help of the state. And for example, if the state itself is breaching that right, so will the state will promote you or permit you to do that? No. So that is the one of the loophole is that you need states to represent you in the international forum. And if the state itself is breaching that right, so itself the state will not permit you. So this is the main problem, that without the help of a state, an individual can't bring that matter to the uh, to the international forum. So individuals are on the basis of different documents. You will find that the individual have given rights to the individual. But when you look in more deeply into these documents, you will find that you need a state to be represented to international forum. So this is one of the major loophole, that without the help of this in your own state, and there can be a situation, or the most of the time the situation is like that the state itself is breaching those rights. So what will happen to that particular uh, time when the states is breaching? So the individual can't bring that matter to the international forum. So the concept is quite clear. The rights are there, but you can use that rights by way of through your state only. So what is the use of these rights? Because it's, for example, I'm just giving an example that you have right to complain about anyone, but while you are going to complain, that you need the help of your class coordinator. And for example, you have to complain about that person only. For example, I am your class coordinator, so you will complain about me. So you have a system to go through me only. So that this is the position of individual also. For example, I have to complain about my position in international law, so I have to look into through the state only. So without the permission of the state, without the representation of the state, I can't bring any matter to the international forum. So this is one of the loophole. We have the rights, you have the right, but you without taking my consideration, you can't bring any note, you can't question anyone. So this is very much we can crucial in nature, that we say about position. So the position is very much crucial in the present situation. The another important right, that is right to make petition. Now when you are saying that there is right to human rights is there, so in a way, there if there is a breach of that thing, you have right to make petition also. So the optional protocol to the Covenant on Civil and Political Rights of 1966 provides for the petition by the individual before the Human Rights Committee against its own state. The Convention on Elimination of All Form of Racial Discrimination of 1966 also provides under Article 14 that the Committee on the Elimination of Racial Discrimination shall receive communication from individuals or group of individuals for the violation of the human rights mentioned in the Convention. Even Article 22 of the Convention against Torture and other cruel, inhuman, or degrading treatment or punishment of 1894 and Article 75 of the International Convention on the Protection of Rights of All Migrant Workers and members of their families of 1990 also provide for the individual petition. That means there are so many documents, there are so many additional protocols of civil and political rights are there. There are convention elimination of all forms of racial discrimination are there. There are uh, convention against torture are there. There are convention where protection of rights of all migrant workers are there. These all important conventions provide individual petition. That means these all documents provide that if there is a breach of your right, you can bring individual petition against your state also. So this is the rule. But now rights to make to individuals to make petition before the international forum are available only at the instance of the state. So this particular thing, whatever we have discussed right now, that every convention, most of the convention try to give position to the individual. But when you add proviso in that proviso, what the proviso say? The proviso say that whatever things were mentioned above will be valid only if the state is permitting you to do so. That means if I have to bring any matter to the state against my state, I need the assurance, I need the permission, I need the support of the state only. So do you think that is possible? Any state will allow you to bring matters on international forum against the state itself? No, no, but no state will allow that. So this is one of the major loophole that a state never support you for anything which you brings against that state. So is it possible? No. So one of the major drawback of this all international convention that we have put very much, we can say we have arranged something in golden letters, but we are not, now what we have done to that golden letters, we have put that in an iron cage. Everything is quite good. I've put everything, all the things I have provided you in very good nature. But what I have done, I have thrown you into the pond, or I have thrown you into a forest. So whatever good things are there, these things are basically diluted by only one thing, that you need a state to represent yourself in, for bringing any matter against your state. So is it possible? Any state will allow you? No, no state will allow you. So that's why the whatever things come into, we look into that, if there is a breach of rights of individual, we will look into that. No individual have ever tried to bring that matter to the international forum, because the state is not supporting their uh, uh, petitions. Some regional convention also have provided petition mechanism. The European Convention for the Protection of Human Rights and Fundamental Freedom of 1950 lays down under Article 25 that the Commission may receive petition from any person, non-government organization, or group of individuals claiming to be victims of violation by one of the high contracting parties, provided the state concerning which a petition is made has declared that it recognizes the competence of the commission to receive such petition. That means I have given this example again and again. Human Rights Commission, European Human Rights Commission, I have given many times. So in that particular commission, there is a provision for bringing rights to, or bringing petition against your own state. You can, individual can bring petition, international organization or NGOs can bring petition, group of individuals can also bring petition. So these all are given in the European Human Rights Commission. But what it said, if you look into the other section, other articles of those European Human Rights Commission convention or treaty, you will find that the state have to recognize that there is a competency of the Human Rights Commission to look into that. For example, if Europe, in the European Union, I think 27 members are there, 26 or 27 member countries are there. So every state should recognize the competency of the Human Rights Commission. If that state is recognized that competency of the Human Rights Commission, then the individual of the state can bring matter against their own state. So whether the state will allow that, in European Human Rights Commission, it is possible because the state has recognized the competency of Human Rights Commission. But is it possible to other commissions? No, it will not be possible. So this type of situation is basically, when you look into this type of situation, you will find that most of the time the power is given to the state, and we just so that we have given power to the individuals, but we are basically represented by the only by the state, and without the representation of the state we are unable to do anything. So individual position is quite clear. We have not given directly access to them, and we have not given direct access to the individuals to be part of international forum, but we have basically provided them the opportunity through their own state, and the state will not, if there is any breach by state, the state will not support those individuals, because the state will say that we will what the state will say that we will provide you support here. We first of all use your own all or whatever rights and opportunity you have in your own state, then we can look forward also. But that is not possible. States never give you access to be a part and to represent you yourself in international forum, and that can, if that particular point can degrade the image of the state. So this is very much important, that the representation of individual on international forum always require the assistance, permission and support of the state. So whatever petition is there, whatever rights are there, all things are basically paper tiger, because without the support of the state, you are unable to achieve that particular target. So this is right to make petition is there. In many documents you will find the right to make petition, but how many times these petitions are successful? That is also one of the important concern of the this international law, because these rights were not given directly to the individual. It we can say it is an via it is an rights which is given through the state only. So state has power to represent, and the state most of the time not represent their individual, because they know that that particular right can be harmful for the image of the that particular state. For example, if you look into the that um, Kulbhushan Jadhav case, Kulbhushan Jadhav was not given consular access, and that was one of the important point. And through the India has are basically questioned this particular point to Pakistan, and they have taken this matter to the International Court of Justice. And finally, the International Court of Justice said that a proper fair trial should be given to the Kulbhushan Jadhav. So this is what Kulbhushan Jadhav was not represented through his own way, because he was not a citizen of Pakistan, he was citizen of India. India recognized that he is our citizen. So on that basis, India has represented the matter to the International Court of Justice. So in the same way, if you are going against your state, the state will not support you, because the situation was different in case of Kulbhushan Jadhav. But if, for example, if right now I say that I want to there is some breach of my rights and I want to bring claim against India, will India will support in the same way that he supported the Kulbhushan Jadhav? No. So that is the position the individual in the present scenario. If you look into the present scenario, we'll find that this present scenario the individuals have nothing in, we can say nothing in solid is provided. Everything which is provided is in document form. So we are unable to use that particular form. Another important right which is given to the individual is another topic, which is right to conciliation and arbitration proceeding. That means you can, this right is basically available to the individual, and this right is related to the right we can also relate with the international investment law. What is the position of individual in international investment law? So you will find that the individuals have given right to be part of any investment. For example, if any individual has invested something in some host state, if there is any dispute, that particular individual can bring claim against that particular state through without the representation, without the support of his own state. So that is one of the important point in relation to the position of individual. So the position of individual is more we can say is good, or we can say better in in comparison to the position of individual is better in international investment law as compared to what is in the position of individual in public international law. So international investment law, the position of individual is far more better than the position of individual in public international law, because here you have the right to represent yourself without the support of your own state. When you look into the exit convention of 1965, private investors who are nationals of the state party of exit may institute arbitration proceeding in regard to any legal dispute arising directly out of an investment against any other contracting state in which they have made investment, provided that the host state consented in writing to the exit arbitration. That means if you look into this particular 1965 convention of exit, it say that settlement of, it is basically international convention for settlement of investment dispute, exit. So if that is what the exit say, that if there is a private investment is there, and if is any dispute arise out of that investment, so you can bring any claim against the host state. That means where you have invested, and on that basis it also say that the other state, host states, could have given uh, his basically given his permission, that while signing that investment he has given their consent, that if any dispute will occur, you can bring the arbitration clause, you can opt the arbitration clause. So investor, if you are investor, for example, and you have any dispute in, for example, if, I'm just giving an example that a person of French origin, he is investing in India. So while investing in India, out of his investment, there is a dispute created, some dispute occurs, and in that particular dispute, that French individual have right to claim, because that was his private investment, and on that basis he has some right to claim, and he can start the arbitration proceeding regarding that investment, regarding that breach of contract, regarding that anything which is related to the his investment. Only that is related to his investment, nothing else. So that right is provided to the individual. A directly investment related legal dispute for the purpose of convention may arise not only from the breach of the diagonal investment related contract between the state and the investor, but also from the breach of international investment agreement, often a bilateral investment protection treaty concluded between the home state of the investor and the host state. That means the breach can be occur in two ways: by the investment, by the individual investment, or by the bilateral investment treaty also. Now, there can be conflict on that basis also, and in that case, the state will come into picture. But where you have a private investment, so in that case, you can bring the arbitration proceeding against the host state without the support of your own state. So, international investment law is more, we can say, give more access to the individual as compared to what the public international law gives. So if you are investor, if you are private investor, you are investing some XYZ country, so you have the right to bring arbitration proceeding. But if you are individual, you can't bring anything in against your own state because you need the support of your state. So arbitration in the investment law is more secure, and you can have some position as an individual also. But in public international law, you can only be represented by your own state. So this is the current position of the individual in international investment law. There is another one point which relates to the position of individual in international law, that is the position in international criminal law. So what is the position of individual? The position of individual here is, as for creating responsibility, we recognize individual, but for creating rights, we don't recognize individual in public international law. So in international criminal law, if there is any, if you individual has done any international crime, then that individual will be basically punished for that. So crime against international are committed by men, not by abstract entities. For example, it is not like that the entity, the state will do any action, or if state is basically doing any action, it is uh, the individual who is committing that crime. For example, you all know about Nuremberg trial. How many of you know about Nuremberg trial? Anyone? न्यूरमबर्ग ट्रायल के बारे में कुछ जानता है? कोई नहीं जानता है? न्यूरमबर्ग ट्रायल जो हुआ था, जो इंटरनेशनल मिलिट्री ट्रिब्यूनल वाज क्रिएटेड, एंड इट वाज आफ्टर द एंड ऑफ वर्ल्ड वॉर. इट वाज अगेंस्ट द नाजीज जर्मनी के. इट वाज अगेंस्ट द जर्मन पीपल. इट वाज दैट न्यूरमबर्ग ट्रायल वाज स्टार्टेड इन 1945, and that particular international military tribunal was created by Security Council, and in that particular tribunal, the question was that who is the main culprit of this whole what was the crimes were done by the war, we can say the genocide, basically genocide or crime against humanity, the word they have used, that what was the who are the basically the culprits. So during that particular trial, the concept, this particular this was the line said by the uh, one of the judges, that the crimes against international law are committed by men, not by abstract entities, and only by punishing individuals who commit such crimes can the provision of international law can be enforced. That means if any state has done something by in any international crimes, so that state can't be punished because the state is not in physical form. You can't punish any state. So who you will present? The people who was representing that state. So because at that time Hitler already had suicided. So after that, who will be there? The commanders of that particular these Nazis were there, and they were basically tried for the these inhuman activities, crime against humanity, genocide. So on that basis, they have tried to question the these people, and they have punished these people by trial. So in international criminal law, if you look into this, that when you have to bring out responsibility of individuals in international criminal law, they recognize individual. There is a concept of individual criminal responsibility also in international criminal law. We say that individual can be responsible for any crime. Not this, you can't. Can you punish a state? No, you can't punish a state. So you have to punish those people who are basically representing the state. So in international criminal law, you will find that state can be by way of we have to punish, or we can basically bring those people under trial, those people who are involved or who are representing that state, who are the powerful people who can decide things. So in international criminal law, individuals have given the right, and we recognize individuals, but in a way we provide responsibility, not we provide rights to this individual. So it is basically the judgment which Nuremberg judgment was there, that against the major war criminals of 1946 assumed the direct imposition of obligation on individuals under the international. It was submitted that international law is concerned with the action of the sovereign state and provides no punishment for individual. Further, that where the act in question is an act of state, those who carry it out are not personally responsible but are protected by the doctrine of sovereignty of the state. In the opinion of the tribunal, both the submission must be rejected. Now, the state basically say that whatever action these individuals have done, they say that these are actions of the state. But what was the output? The tribunal said that state can't do anything. Do you think the state can take action? No. The individuals who are related to that, the individuals who are basically representing that state are responsible, and tribunal say that state can't do anything and you will be punished for that. Individuals were punished for the Nuremberg trial, after the Nuremberg trial, and this is the position of individual in international criminal law. So that in international criminal law, we create responsibility to the individual, but in public international law, we don't provide the rights to the individual. So at present, the individuals are not directly subject of international law. We through the state can be subject of international law, but it depends on the state whether the state allow the individual to be represented or not. So this is for the topic individuals and subject of international law. Do you have any question? Prabhav, any question?
No, sir, not from my side.
Anyone? Varun, Nancy, Srishti, नवीन,
नो
आप लोगों को क्वेश्चन नहीं आता दिमाग में? क्यों नहीं आता बताइए? हमें तो बहुत आता क्वेश्चन दिमाग में, पूछना नहीं चाहते हैं। सारा समझ में आ गया, मैं पूछ सकता हूँ दोबारा? चलिए साक्षी, आप बताइए क्या पोजीशन है इंडिविजुअल्स का इंटरनेशनल क्रिमिनल लॉ में? क्या पोजीशन है साक्षी? साक्षी, आर यू देयर? व्हाट इज पोजीशन ऑफ इंडिविजुअल इन इंटरनेशनल क्रिमिनल लॉ? मैंने अभी जस्ट इसको कंक्लूड किया है, बताइए। योर माइक इज वर्किंग, योर, अच्छा आपका माइक नहीं वर्क कर रहा। चलिए, और ऐसा कौन है जिसका माइक नहीं वर्क करता है? आयुषी बताइए, आयुषी अग्रवाल, आपका माइक वर्क कर रहा है ना? आयुषी, आर यू देयर? आपका माइक वर्क कर रहा है? ऐसे कैसे होगा बताइए? कोई कुछ पूछता नहीं है, कोई बताता नहीं है, तो कैसे चलेगा? कितने लोग सुने हैं पूरी क्लास को? पूरा जो अभी तक का लेक्चर कितने लोगों ने सुना है सही से? हाथ खड़ा करो। बस 3 लोग, 5। आप बताइए क्या समझ में आया? 5 लोग जो हैं बताइए, हिंदी में ही बताइए क्या समझ में आया आपको। प्रभव, you start. I know most of people will not say anything.
Sir, as you explained the judgment of the Nuremberg
Nuremberg.
trial, yes, a Nuremberg trial, and you said that it's at, in a way, sir, you said that it's at a milestone for the revolutionary judgments for the first time, and it is that said that the it was held that for the heinous crimes we cannot hold abstract entity like states responsible for that individual for that heinous crimes, but we can say that the individuals are responsible for that crimes, and hence the transactional criminal justice cannot be done unless we can punish an individual. Sir.
Yes, because in this particular international criminal law, we are providing that we are recognizing individuals, but not as in subjects, but we are saying that it is an object of international law,
Yes, sir,
international
not
criminal law. And without, we have to punish these individuals because we can't punish the state, because the state is not in physical form. You can't punish a state. So for those people who are representing that state, they are basically trying to avoid this responsibility by saying that whatever we have done by way of the under the garb of that we are sovereign in nature, you can't punish us. But the court has said that as a state you can't say that as a state can't do anything. We know that a state can't do anything, but as you have representatives of the state, we will punish those individuals who have done anything, and because we can't punish the state. So in international criminal law, we are saying that we are creating responsibility. We are recognizing individuals and we are creating responsibility on them. But in public international law, we are not recognizing individuals as subjects of international law. So this is a basic difference between that in the same international law, in different areas we recognize individuals, and in some areas we don't recognize individuals. So in investment law we recognize, in international criminal law we recognize, but in general public international law we don't recognize because we are represented by our own state, and the state will not support you for anything which is against the state itself. For example, if I have to bring any claim against India, India will not support me on international forum. So in the same way, because most of these powers are given to the state and individuals are represented through the state, so the position of individual is not quite clear. It is very whatever they have written in the documents. I'm not saying the documents are not there, but these documents are basically paper tiger. These documents are useless because we have to go through the state only, and the reason they don't want to bring individuals into the as in subjects of international law, the one of the reason which I can conclude is that when we will do that, there will be more and more claims in the International Court of Justice, and that the same position what is of present of Supreme Court and High Court and the District Court, the same can be the position of International Court of Justice. Right now, the International Court of Justice is deciding many few matters, but when these particular subjects of international law will come into picture, as the individuals will become subject of international law, that scenario will be different. And the another thing is that you can't bring anything. For example, we have to go to for bringing that matter, you have to bring that international. You have to go to the International Court of Justice. So these possibilities not there because you have to go to Hague for that, and you have not. Most of the people have no access to go there. So so this is one of the reason which I can conclude. So they have not provided and they have given powers to the state only. ठीक है, नेक्स्ट टॉपिक अभी स्टार्ट करेंगे, कल करेंगे, बताइए, मंडे करेंगे, जैसे बताइए आप लोग।
सर हम लोग मंडे को शेड्यूल कर सकते हैं।
ठीक है, चलिए, तो मंडे को हम लोग कस्टम्स पढ़ेंगे। नाउ वी हैव कंप्लीटेड आवर यूनिट 1 एंड वी विल मूव टू यूनिट 2। ओके। तो ये चलते रहेगा तब तक आप लोग फिजिकली भी आ जाएंगे, तो देन वी हैव द फिजिकल क्लासेस। एंड राइट नाउ वी विल स्टार्ट विद द कस्टम. Custom is one of the important and one of the critical topic of sources of international law. So on Monday we will discuss that. Okay.
यस सर, डेट शीट भी आ गई है कैट की?
कैट की डेट शीट आ गई है शायद, अभी उसमें कुछ चेंजेस होंगे इसीलिए शेयर नहीं किया होगा उन लोगों ने।
सर कर दिया ऑफिशियल ग्रुप पे।
अच्छा ऑफिशियली आ गया।
यस
चलिए मैं आइए जब संडे को लेना होगा मैं इन्फॉर्म कर दूंगा आपको, कल तक आप लोगों को इन्फॉर्मेशन मिल जाएगी, ठीक है।
ओके, थैंक यू सर। कैन वी लीव सर?
हाँ हाँ लीव कर दीजिए।
बाय सर।
बाय।